Does your client agree to share his credentials to a social media account with everybody else in this case at this stage?
I'll
try it. Let me call page 5. This is case number 822-859-490C. This is Wesley Robertson versus Kody Gorden. Okay, let's start with plaintiff's counsel.
Good morning, Your Honor. This is Bre'Ahn Brooks on behalf of the Robertsons.
Good morning, Your Honor. Sean Payne on behalf of the Robertsons in their capacity as counter defendants in this case.
All right, good morning to both of you. Okay, defense counsel.
Good morning, Judge. Loren Young for Michael Stiles.
All right, good morning, Mr. Young.
Good morning, Your Honor. Gazda for Michael Stiles, defendant and counterclaimant.
Good morning.
Matthew Friedman on behalf of Fraser.
Good morning, and I think we have Mr. Backus online.
Yes, Your Honor, appearing for AVGA Baseball LLC, DBA Rawlings Tigers.
Okay, let me ask, I think there's a little bit of split here. So I called this Rule 16.
Oh, good morning, Your Honor. Sorry.
Oh, I'm sorry.
Sorry to interrupt you. Kate Ludwick here for Dale Hayes at a deposition today. So we're here for Kody Gorden and Tigers baseball.
Yes, how could I forget the first name defendant? I apologize. Thank you. Okay, so it seems to me, if I remember in reviewing this JCCR and the reason I called this Rule 16 conference, and you all don't have to remain standing, by the way, unless you want to.
Thank you.
There's a little bit of split in how the parties would like to proceed, and I think the split is largely between defendants as a whole and plaintiff as a whole. Defendants, would you like to anoint someone to speak on your behalf on your position?
I can, and then they can fill in the gaps with anything, Judge.
Great. So why don't you, because I think you're taking and I don't mean this in any pejorative way, but the deviating position from the ordinary course. So tell me about your position and what you think of it. And I know part of it is I suggested the parties may want to consider phase discovery in this case. So
Correct, Your Honor. And I think given the allegations and the factual assertions, I think it does need to be staggered because the facts need to be really established of what happened and who said what and when they said it. And I think that's why the defense has talked about starting off with it. I don't know if it needs to be, if it's a stage or it's a phase, but the first part, everyone needs to participate in the ESI part. Get everyone's electronic devices submitted so we can get that information out off the electronic devices or any other online social media type stuff. And then the next phase we would propose would be written discovery. And then based upon that, we need to understand who the witnesses are. So that would be the written discovery. And
all right, hold on. Let me understand it. So you would propose, because, and you're doing the correct thing. In order for me to order phase discovery, I have to have an appreciation of what every phase is going to entail and the purpose of doing every phase. So phase 1 is effectively, you want to do an ESI preservation phase. That's not really, that in and of itself is not really a phase of discovery. Everybody should be preserving their ESI, and I assume everybody has preserved their ESI consistent with their obligations under the law here. So I'm having a little bit of disconnect on phase 1 because in my mind, that's not really a phase. That's, hey, you all should be doing that. Are you talking about turning over ESI to one another in phase 1? Because you still require discovery requests for that.
Well, correct. Your Honor. And that's why I was trying to say that should be done by everybody initially. I think everyone understands that everyone needs that from every other party.
Okay, but what I'm saying is that everybody should be preserving already. I assume the preservation has already been done.
Well, I'm hoping, but nothing's ever been produced, despite the fact that it's closed.
But what I'm saying is everybody doesn't have to wholesale turn over their ESI. It's not as if suddenly the plaintiffs here have to turn over everything that's on their cell phones. Conversely, defendants don't have to turn over everything on their cell phones or laptops or cloud or whatever. You still have to make requests for what is relevant. And that's why I'm having a hard time understanding the first phase, because it's not really a phase. And maybe it's a matter of semantics. But what I'm trying to figure out is, are you actually asking for everyone to turn over all of their ESI?
Well, I was hoping that the parties could get together and have a type of what is relevant to the allegations. For example, cell phones and iPads that have text messages in those relevant parties for that particular period of time. I think that should have been produced given to everybody. But as Your Honor said, you do have to do a request. So if that doesn't want to be a phase, then we can just merge that into the written discovery phase and everybody can do their written discovery and then we can move on to fact.
Okay, so you're basically just wanting to break up depositions from written discovery. Do all the document discovery first, and then once document discovery has closed, which I'm guessing also includes RFAs and interrogatories, then move on to the depositions. Is that effectively your plan?
Correct.
Proposal?
And I think and I guess that phase is really all limited to fact issues. So then we can worry about damages and experts after that stuff gets established. Because I think at that point, there's going to be potential change.
Okay, so you're thinking 2 big phases: fact discovery, expert discovery. Within fact discovery, we do documents and written discovery and then depositions. Once that closes, we move on to expert discovery. We do expert disclosures, and then we do expert depositions. Is that a fair?
I think that's a fair, description of it, yes.
Okay, let me hear from the remainder of defense counsel to make sure they agree. All right, those in the courtroom?
Nothing further to,
Okay.
I saw you jump up.
Oh, we're
Yeah.
I'm gonna get to plaintiffs counsel in a second.
Counter defendant.
Oh, okay, sorry.
I
Non-counter defendants.
I would agree. I think.
Your Honor, Gene Backus,
Go ahead, Gene.
if I may, Your Honor, we did submit earlier today proposed ESI protocol order. We had intended to have that attached to the JCCR, but somehow it was overlooked and didn't catch it until today. I think what we really need here, instead of just engaging in written discovery, the court is pretty well acclimated to the issues that were presented, at least with the motion practice early in this case, the sanction motions, the counter motions, that in large part deal with text messages, emails, Instagram posts, videos, photographic images, that sort of thing. It would be good to have out of the chute, instead of having written discovery, have an order of the court requiring the parties to identify all devices whereby any information was exchanged relevant to the issues that have been presented to this court, and to identify the ownership of any of those social media platforms, and to require the parties to divulge their credentials for those social media platforms and postings, so that access could be gained to that. If it's a third party that has to be sought out, then that information would be available. So we would recommend that the court enter a protocol order. My only experience in this case was with the city center litigation, where Judge Gonzalez entered a very comprehensive ESI order. That case involved a lot more data than our case presently. I think there was like 12.5 terabytes of data in that case. And she actually appointed an ESI master, Craig Ball, to actually monitor the ESI. I don't think that kind of level is necessary here. I don't think we need a master, but we should have upfront disclosure of all of the devices that were utilized. You're right, they should be preserved, but we need more than just preservation. We need identification of what these devices are. A further comment I would make initially that is kind of, I don't know, just a particular issue that I have with the practice that goes on in our jurisdiction, and that is with 16.1 disclosures. My reading of 16.1A is that the parties are obligated not only to identify witnesses, not witnesses, but identify persons with knowledge, but they're also supposed to identify the subjects of the information that those individuals may have. And the purpose of that disclosure is to allow the other parties, because there are a ton of potential individuals here that have knowledge, what these individuals may have knowledge about, so that we can make an informed decision as to whether to take a deposition down the road or not. And typical in this case and many other cases, all the parties do is they just say, well, this witness is going to testify or may have knowledge about the facts and circumstances in this case, which tells you absolutely nothing. There's no point of the disclosure. So I would like to see all of the initial disclosures made by the parties to be more descriptive of what the information is for each particular individual, so that we can have some ability to have a comprehensive discovery plan and not have to take 100 depositions because we don't know who people are. We did suggest in the joint case conference report that there should be a protective order, but Your Honor went ahead and issued a protective order on your own, so that is not necessary. But I would like to see that first phase of the electronic discovery. A lot of this case deals with electronic discovery. I think an order, an ESI order, we've submitted one to Your Honor earlier today at your email address. We've also served the parties with the proposed ESI order that we thought was going to be attached to the joint case conference report, but was not. I know other counsel have circulated proposed ESI protocol orders. They may want to submit to Your Honor their versions of ESI orders, but I think we need an order. We need an order of what needs to be done, how it needs to be produced, what the metadata is. The metadata that, is going to be important in this case as to who deleted what, how it was deleted, if it was deleted, that kind of thing. And that, I think, an ESI order would like Your Honor to consider. So for the first phase, there was a recommendation in the joint case conference report of going up to, I believe, October, taking limited discovery up through that point relative to the issues that were before the court on motion practice before full-blown discovery was opened. So I think the first phase of discovery, to answer your question, from at least my perspective, is not just ESI. I mean, that certainly is from my client's perspective, the most important issue, but identifying all those devices, identifying all the social media platforms that were involved, all the credentials, get that out, have that, all that produced. I think it should be produced pursuant to the ESI order, not wait for the written discovery, have the order requiring that to be produced in the format that preserves the metadata. So we can see the underlying, have our experts look at it. I think that's fundamental. Then there's been some suggestion by the parties that after an initial phase of discovery, and that first phase of discovery, I believe, should go to the issues that were before the court in the motion practice. Maybe some written discovery, if necessary, to follow up on that. And then potentially a mediation before we go into full-blown discovery. I would say that the depositions of at least the principals should be taken in this case before in phase one, in addition to the written discovery. And then following that, a second phase where any and all witnesses can be deposed, and then go in the traditional expert disclosure and the typical kind of discovery scheduling order that this court is quite familiar with.
Mr. Backus, let me raise one point of clarification. When you say the credentials for social media, are you contemplating that the parties share not only their usernames, but also their passwords?
Yes.
So try to move me off my position, but the problem I have with that is that there's going to be obviously very relevant information stored on the social media platforms, but there may also be completely irrelevant and personal information stored on the social media platforms. The photos and stuff, like on Instagram, which may or may not be public, I don't know if that can probably be protected with a confidentiality order. But what I'm concerned about, Mr. Backus, are the direct messages, the DMs. And I'm not prepared. I'm not prepared to give each party wholesale access to another party's social media messages. That's sort of like just giving someone the keys to their email inbox these days. So is there any reason why the sharing of the credentials and full access by each and every party to every other party's social media is required?
Well, from my client's perspective, Your Honor, and most importantly, I can't speak for everyone else, but the reason that ADJ Baseball is in this case is a broad accusation that somehow we control this social media, which is absolutely not the case. So ownership, all the details about the social media accounts are important. And I'll get to the issue of credentials after that, but all the ownership, all the access to the social media should be disclosed. I think at that point, it'll be clear to this court that my client had nothing to do with any of these accounts, had no control over these accounts, where any of this stuff was posted. So my issue is more of a jurisdiction issue, more of a liability issue for my client. But going to the credentials issue, I think there's a real issue in this case as to whether parties have been forthright in producing all of the underlying text messages and Instagram posts and videos and photographic images, whatever's out there. You've got a confidentiality order that can protect that stuff. At some point, the issue of getting to go behind the closed door, so to speak, and really see whether there has been a forthright production or not, I think is going to come to bear here, and that's where the credentials will come in. Now, that certainly does not have to be initially disclosed, but I think at some point the court's going to want to do that because it seems to me clear that a slew of information has been produced by the defendants in the way of electronically stored information and has presented to this court in the way of motion practice with attachments and exhibits where there has not been, I believe, a total forthcoming disclosure by the plaintiffs. So I think that needs to be fully disclosed, and I think I'm really leaning towards more of the plaintiffs disclosing, but if there's all fairness, it should be on both sides of the fence.
Okay, so I'm going to go back to defendants, the remaining defendants who are in the courtroom, as well as Mr. Gordon's counsel online. Before I get back to plaintiffs, what I'll say is I think most, not all, but most of what Mr. Backus is saying makes sense for the phasing, including the ESI protocol. Mr. Backus, I don't have your ESI protocol yet. I don't know if you sent it to my law clerk or if you submitted it to the department inbox.
The department inbox, yeah.
Okay, it hasn't come through for some reason yet. I don't know if the hamster wheel is simply turning and trying to trying to process it, but I don't have the ESI protocol yet to make any comment on the protocol, but I certainly think as a conceptual matter, without getting into substance of exactly what that protocol would say, I would tend to agree that in a case such as this, where ESI is incredibly relevant, an ESI protocol makes sense to me. But the person who I haven't heard from yet is Mr. Gordon's counsel, so let me make sure she has an opportunity to speak.
Yeah, thank you, Your Honor. We agree a lot with what Mr. Backus said. We need some kind of identification of what we're working with. Plaintiffs claim that they did all this due diligence. They talked to all these witnesses, they produced or reviewed all these text messages, but they haven't disclosed any of that, right? We've disclosed hundreds of text messages, but we don't really know what they're basing all of their claims on yet. And so, especially if we're looking at for phase one of discovery being focused on disclosures and requests, it's really crucial to have basically identifying exactly what witnesses that we're dealing with, what social media accounts, what other devices that we need to preserve. So we definitely agree with Mr. Backus.
Does your client agree to share his credentials to a social media account with everybody else in this case at this stage?
I mean, honestly, you know what, Mr. Hayes did not. Well, I know that Mr. Gorden is definitely willing to be forthcoming. I don't know. I mean, we didn't discuss whether giving up the credentials for all of his social media accounts, so I'd have to just discuss with Mr. Hayes. But in general,
I would discuss that with Mr. Gorden, because I know
Yes,
I
please.
would be remiss to just give up my password, and I'm assuming for the gentleman sitting in front of me, you might want to discuss that with your clients to the extent you haven't, because I bet you wouldn't want to give up your passwords either.
Your Honor is very correct. Obviously, the difference between our clients and Mr. Backus is our clients are individual human beings. They're not a large organization, right? So to me, if you get the ESI protocol in terms of preservation, and along with that order to, I think, several people's comments, there is a mandatory disclosure of all relevant information, not on ESI, but anything relevant material to these claims. That goes a huge way to addressing, I think, Mr. Backus's and my co-defendants counsel's concerns. That's what you need there. Right. So, and then I would, from that position, I would agree with what Loren and Jean said in terms of sort of the staging of it. I think it makes a lot of sense. Liability is, from my perspective, still very, 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 very unclear, even the premise of it. So I think that sort of seems to be the bulk of the first phase, and then you look at damages from that point forward, right?
In addition, Your Honor, I think under the ESI protocol, if the witnesses are identified or the people with information are identified, and disclosed.
Which is the 16.1A issue that Mr. Backus raised.
We could then the focus could be made on those devices or accounts on those people, and it wouldn't be just unfettered. Mr. Gazda and I were talking about this a little bit, and I'm a little bit unfamiliar with this process, but I mean, maybe the credentials that are produced provided to the expert who's retained, and then he's given the scope of the witnesses and everything, and then he goes through and filters it all out and obtains that information.
So I think even Mr. Backus walked this back a little bit. I would probably not order, in fact, let me make that even more clear. I would certainly not order the production of credentials at this stage. What it really is it's discovery on discovery. And discovery on discovery is not appropriate unless there's been some initial showing beyond your fear that everybody hasn't been forthcoming in what they've produced. So once I have a showing of, hey, these documents should exist, they don't exist, then I can start ordering discovery on discovery, including up to, hey, I'm going to appoint a special master here, including possibly an ESI special master, who's just going to go around and they're going to gather everything from your social media accounts. They're going to filter out the stuff that's irrelevant, and then we're going to talk about the stuff that's relevant. But that is, in my view, a remedy far down the road from where we are today. I haven't heard from plaintiffs' counsel and counter defendants' counsel, so let me hear from counsel on to my right here.
Thank you, Your Honor. So, I mean, our main position for kind of pushing back a little bit on this whole idea is that, in our opinion, it really overly complicates things. We're talking about rules that are already in place. So there's
a rule for phase discovery.
Correct. However, there's things called subpoenas. So we're talking about sharing credentials. We can subpoena Instagram, we can subpoena Facebook, we can subpoena Words with Friends. A subpoena is going to be more efficient than providing credentials because the subpoena is going to give us everything, the metadata, the logins, the pictures.
Tried subpoenaing Meta before?
It is. However, that is an avenue of discovery that's available to us. And that is not going to, our clients are definitely opposed to providing their credentials. We're also
I already said I'm not. We can move on from the
for
credentials
sure.
because I already said I'm not ordering that today. So, but what I want to hear from you about is I want to hear about the phases. I don't want to hear about subpoenas right now. I want to hear about why you object to the phasing of discovery in this case.
So we're not necessarily objecting at this point. I think there just needs to be a little clarification in terms of what is going to be happening in these phases and how it's going to be judicially efficient. So we're talking about phase one, and phase one, they want to gather information. Okay, well, that's written discovery, but only written discovery on certain things, and then later written discovery on other things, and then later depositions. It just seems overly complicated. And maybe we can just extend our initial period prior to experts a little longer, push experts out a little more. But I think that we have to gather all information to be prepared to start taking depositions. And so if we're only focused on liability things, then we still have to go through another phase of discovery for damages before we can take depositions. And so I just want to be clear what is allowed during the phases, what is not allowed, what exactly are we talking about? Especially with identifying all devices. What does that mean? You want me to tell you if my client has a laptop or not?
Yes.
She does.
Yes,
You want
that
me
is.
to tell you if she has a cell phone or
That
not?
is everything that she used to
So,
communicate. And
correct.
you don't have to tell me now, but that is exactly what the identification of devices is.
And I'm fine with that, but I don't see how that can be accomplished through regular written discovery. And so instead of us serving 10 sets of ROGs and this set goes to liability and this set goes to damages experts, why can't we just serve all of the interrogatories? You know what I mean?
It's
feel like
to save on costs and not allow. I know exactly where defendants are coming from, and one of the reasons I suggested this is because this is a very unusual case, and the claims that your client has brought, they pass. You won your Rule 11 motion, right? Or you won your opposition to defendant's Rule 11 motion. You won the motion to dismiss in large part under Nevada's relaxed pleading standards. I don't know I haven't seen the evidence in this case, and they're right. They produced a bunch of stuff. You didn't produce a whole lot of stuff.
We produced everything that we have.
That is concerning to me, and I think that's defendant's point here, is that you don't seem to have a lot of stuff.
A lot of stuff, especially Rawlings Tiger, especially Tigers LV Excel. There's not a lot of stuff. There's a few text messages that, again, are pulled out of a context of a whole conversation that they produced a few pages for, to be fair. But we have not started discovery. So I think it's unfair to say you haven't produced anything. We produce everything we have without getting discovery to pull documents, do a forensic analysis of cell phones and other devices and all of those things.
And I will tell you, the fact that if you have in fact produced all copies of all text messages and social media and direct messages that you have, the fact that you don't have more is concerning. It means that your client at some point was deleting information.
So on that same notion, they haven't produced anything from Instagram, anything from Words with Friends. They haven't produced anything from Facebook. This is the crux of majority of the conversations they were having and majority of what the photographs were being shared. They also haven't produced any photographs. So I think that's unfair to say about my client when they haven't produced a single photograph, a single Instagram post.
You're deflecting right now from the real issue. So I'm going to hear from counter defendants.
Yeah, I think, Honor.
Counsel.
Thank you. I think we're departing a little bit from what you want to discuss, and I do echo some of the points that Mr. Backus made, and agree that if an order from the court was issued that required the parties to produce a lot of this information at the early stage of the case, it would preclude written discovery. I mean, you see the amount of attorneys that are in this courtroom, and the amount of parties that are in this case, and that is a concern that we have. Is if we just open up discovery in the normal course, and every single party is serving preventing written discovery on one another.
Don't you all represent the same people?
We do.
Okay.
But we agree. We had circulated a proposal yesterday, and I thought that most, if not all, of the parties were in agreement that we would do this phase discovery and produce all of the information and be able to digest it in order to go to potentially an early mediation before we get into depositions in the case and further discovery with experts and so forth.
Okay, so this is what I'm going to do. I'm not going to delineate all the phases right now. However, I think Mr. Backus' suggestion of what the initial phase, which I think largely aligns with what the remainder of defense counsel was saying, makes sense. And then after that, we're going to have a status check. So first of all, I'm taking discovery back in this case. So you're going to the extent I haven't done that already, you're going to be before me and not a discovery commissioner. If you can't agree and this becomes too much for me to handle, I'm going to appoint a special master. Okay. And the costs are going to be borne by initially 50% by the plaintiffs, 50% by the defendants. Okay, and that's how I'm generally going to do the costs before the special master, and it would be subject to cost shifting under the rules of discovery, right? So you can make a motion to compel and you prevail on your motion to compel, and the other side didn't have sufficient grounds for opposing it and making their objections, then special master can make a recommendation to cost shift. But we're not at that stage yet. This is what I want for the initial phase. I want by August 17th, that's in 2 weeks, I want all the parties to have served on one another identification of all electronic devices that they use, okay? That's in their possession, custody, or control. And all identify, so all devices, all email accounts that they have possession, custody, or control over. For the entities here, you can simply say, I have possession, custody, or control of all email accounts at whatever your entity name is, okay? I don't need to know Bob at rawlingstigersbaseball.com, Gene at rawlingstigersbaseball.com. As the entity, you have control over that anyways. I want identification of all social media accounts and usernames. I do not want passwords. However, I do want usernames, and I want the link to the social media account identified with the username. Okay? Because sometimes, like on Instagram, many people will have the same username, but your link to get to that page will be different. This includes Instagram, it includes Snapchat, it includes TikTok, it includes Meta, it includes, if anybody is using, like Signal, you know what Signal is? Signal is the DM, the direct messaging platform, where your messages disappear within like 8 hours. A lot of people who don't want their messages obtained use devices like Signal and Confide. I want those identified, okay? WhatsApp, that's another popular one. I want that identified. This is including without limitation. So if I am not up to speed on what the kids are using these days and I haven't identified one, I want that identified along with the link and username and credentials. I want to has everybody made their 16, I'm not asking about the sufficiency of disclosures, but have all 16.1 disclosures been made, at least on an initial round? Okay. I want everyone to supplement those to the extent they're deficient with the identification of witnesses. I agree with Mr. Backus. A lot of parties don't care about 16.1A disclosures and they just move straight on to discovery. But Mr. Backus is absolutely right. You can't just say this witness is going to testify about all facts and circumstances in this case. That's hardly any disclosure at all. You might as well not disclose anything at that point. You need to put sufficiently specific subject matter of what that witness has knowledge of. You also, since we're fixing this, unless you as the attorney have authority to accept service on behalf of that witness, you need to put that witness's actual address in the 16.1A disclosure. So that's going to be phase one. I want all of that done by the 17th. And then we are going to meet again on August 24th at 9 a.m. unless somebody tells me they have a conflict right now with August 24th and we need to meet on a different date. Okay?
Your Honor.
Yes.
Yeah.
24th. Oh, actually, the 23rd I have a conflict. 24th I'm good.
Okay. Oh, and in addition to that, in addition to listing, identifying all devices under your client's and social media accounts under your client's possession, custody, or control, I also want you to identify those devices and accounts that were used to exchange any information that would be relevant to this case, or even if you think it's not relevant, if you communicated with any other party to this case through a social media account or through an email or through a phone number or using a device, I want those identified. If you did that and you no longer have the device, because I understand iPhone, I don't know what iPhone we're on these days, 14 or 15, and you no longer have a device, you need to identify that you traded in a device, or you no longer have a device, or you're no longer using a device, but it's sitting in the back of your desk somewhere, like all of mine are. Okay.
For example, Your Honor, if I had like an iPhone 13, I can't just say iPhone 13. Should I put a little bit more information plus like the user account for the iPhone that you use? Is that what you're talking about?
No, I'm saying, you know how we upgrade every year on an iPhone? So if your client, for instance, is up to iPhone 14, but they use their old iPhone 13 to communicate with some of the other parties to this case, you need to say, oh, I used an iPhone 13. I'm no longer using it. I traded it in. It's no longer in my possession, custody, or control. Or you can say, I'm no longer using it, but it's sitting in the back of my desk. Okay. All right. So I will see everybody. Yes, go ahead.
One thing, Your Honor, when you asked in the initial phase to have all parties serve the identity of the electronic devices used, the email accounts used, et cetera,
Yes.
is there a time specification that we're talking about? I mean, because the way it's right now, it's open-ended. It could be up to today.
Oh, that's fair. That's fair. When did this, somebody tell me, when did this start?
Yeah, 2021.
I think it was June.
But July 16th is when the alleged assault occurred.
Yeah, but I
But
think
the
there was
lead
some
up to that was earlier in the year.
Yeah.
2020.
When did
Because it was around the time that COVID was really prevalent.
the Gordon's son join Rawlings Tigers baseball? Oh, sorry. I apologize. I definitely don't want to confuse the parties.
Wasn't that 2018? I think that was.
It's been a while. I think if we're good and you guys,
Yeah.
2020 to probably 20, we'll clear it.
It was about 2020, yeah.
Yeah, because I know it was like in the thick of like COVID.
Okay. Let's say it's from January 1st, 2020 onwards, okay?
Thank you, Your Honor.
Right. And thank you for raising that. That's a very good point. We would be going back to the late 90s, early 2000s.
We said January 2020. You said onward till when? The date of the filing of the complaint? Or
Date of the filing of the complaint.
Okay.
Okay.
Yeah, I know that's kind of it.
So if there's nothing else, then I'll see you on the 24th for an update. Okay, and then in the meantime, Mr. Backus, if we can't find the ESI protocol, we'll reach out to your office.
Okay. Your Honor, if you would like, just because you made a comment about a potential special ESI master, if you would like me to provide you with Judge Gonzalez's City Center order that she created for Craig Ball, who is ESI specialist. She did enter some orders in that regard. I could provide those as well.
That would be excellent. I'm not going to put that into place now, but we'll keep it on file for future reference.
Okay, will do.
Thank you so much.
Thank
I
you,
appreciate
Your Honor.
everyone.
Thank
Thank you.
you.
Have a good day.
Appreciate you too.
Thank you.